So thank you for the time. In this very occasion, I'd like to present part of my ongoing research project for my PhD thesis at Leiden University. My research is about marriage practice in the lower level of society. It questions how does the society understand, interpret, and implement the state law on marriage. And at the same time, it also analyzes the ways state officials at the lowest level of state administration deal with people's varied practices. For the time being, my presentation is about legalization of unregistered marriage in Indonesia. Let me share my screen first. To give you a simple context of what we have in Indonesia right now, we have been observing so-called dual validity of marriage. There are two kinds of validity of marriage. First is religious validity, and the second one is legal validity. According to the state law on marriage, all marriages should be concluded according to the religious teaching of the couples. And the religious marriage should be registered. In fact, there are various reasons why religious marriages remain unregistered. So unregistered marriage is unlawful marriage, but is legal according to religion. My current lecture deals with how retrospective legalization of unregistered marriages works in practice in Indonesian society. It understands what people do to have their marriage legalized. The data in this paper result from my room observation and reading of marriage registration documents in the KUA office. The KUA is an office that deals with Muslim marriage in the context of Pasuruan society in Indonesia, as well as the examination of conversations in the courtroom of the Bangil Islamic Court. It's a local Islamic court in Pasuruan, and legal reasoning used by Islamic judges in the isbat nikah cases. Isbat nikah is retrospective marriage legalization, a judicial mechanism for the doers of unregistered marriage. This paper finds out the significance of administrative transgression played by the KUA officers and judicial discretion made by Islamic judges so that they are able to grant legalization. Applying a lenient approach towards marriage regulation by the lowest level of the state administration is really crucial to provide state recognition of unregistered marriage. Now, let me present my introduction. Abdullah, 44 years, is the husband of Jamila, 40 years. They have been married for 21 years. However, their marriage was only concluded traditionally and hence not registered at the KUA, a practice locally referred to as nikah sirri, or a secret marriage. Therefore, they do not have a marriage certificate. Nevertheless, Abdullah has somehow been registered as the head of household and Jamila as the wife on their family card. Normally, this would not have been possible because they are not legally a couple. When I asked him how this could happen, Abdullah just replied, "I just received it from the village officials," he said. So by possessing this family card, they are accordingly recognized as a legal couple in the eyes of the civil administration. However, although their status is recognized as married or kawin, Abdullah and Jamila still encountered a problem when they wanted to go on the Hajj or pilgrimage. The family card that confirmed their status as married or kawin did not suffice as a requisite document for the Hajj visa application. Under the state law, Indonesian state law, they had to submit a valid marriage certificate to prove they are in a lawful marital relationship. The 1991 compilation of Islamic law, Compilasi Hukum Islam, which serves as the reference for Islamic judges in dealing with Islamic cases in the Islamic court, stipulates that Muslims can legalize their unregistered marriage through a judicial procedure called isbat nikah, retrospective marriage legalization. Although this legal procedure was formulated to accommodate marriages concluded before 1974, it is the time when the legal obligation of marriage registration came into force. Nowadays, judicial practice in the Islamic court will legalize unregistered marriages whenever they have been concluded according to the Islamic teaching, and as long as it can be proven that the wedding ceremony complied with Islamic doctrine. However, given this choice, Abdullah did not choose to propose an isbat nikah, but he opted to apply for marriage registration at the KUA. This means that he would have a newly registered date of marriage, erasing any prior marital relationship between him and his wife. Abdullah had no concerns, or at least objection, to the new date of marriage, although it would give consequences, particularly on the legal position of their children. The children cannot state the names of both parents on their birth certificates because they were born before the registration of their parents' marriage. Now, I would like to present about the significance of administrative transgression in marriage registration. Abdullah's experience illuminates the array of problems plaguing the state-citizen relationship in contemporary Indonesia. Their possession of a family card allows Abdullah's family to enjoy certain benefits from the state. However, the legal status as a husband and wife of the family card was not sufficient enough to meet the requirements for Hajj documentation. In short, Abdullah needed a marriage certificate from the KUA office to obtain a Hajj visa. It was actually not Abdullah who was in need of a marriage certificate, but since he wanted to go together with his wife, to go for Hajj with his wife, it was actually his wife who needed a legal marriage certificate. Because according to the Saudi Arabian regulations, any woman under the age of 45 who wants to apply for a Hajj visa needs to indicate by whom she will be accompanied, or yurafiquha, as her male guardian, as her mahram. In this case, this role was obviously to be assumed by Abdullah. But since he was not officially registered as her husband, this was impossible. One interesting point emerging from this story is that Abdullah used the family card to apply for marriage registration. The responsible authority at the KUA was aware of this anomaly, but still proceeded with the registration. And then the KUA asked Abdullah to declare on paper that he had never registered his marriage before. I tried to obtain clarification on this decision with a person from the KUA, and he said, "We just wanted to help him. It was a pity that he should have to go to the court because it takes time and money. Abdullah just needed an official marriage registration." Abdullah's case reflects the degree of pragmatism practiced in the field. My close reading of marriage registration documents has uncovered what can be called a kind of administrative transgression done by penghulu. Penghulu is marital officials at the KUA, marital functionaries at the KUA. So the importance of administrative transgression was apparent in the everyday functioning of the marriage bureaucracy at the KUA. And the next it's about the isbat nikah done by Islamic court. In the previous section, we have seen how transgression is important in dealing with anomalies in the documentation required for marriage registration. Without this transgression, marriage registration would not be possible. Regardless of this solution, as I mentioned earlier, people in marriages which have not been sanctioned by state legality can request retrospective legitimation by applying for isbat nikah to the Islamic court. In the Bangil Islamic court, isbat nikah appears to be a very workable solution for people who need to declare the legal status of the children. Here, I have a case, a marriage between Hassan, 17 years, and Jamilatul, 17 years too, which took place in January 2013. Although the groom was not yet 19, which is underage according to the state law, his parents did not request for a marriage dispensation. The reason was that the bride was already 3 months pregnant. This pregnancy actually does not make any sense as a reason, but it is mentioned in the decision. Their child was born in June 2013. The couples applied for an isbat nikah in early 2014 because they needed to raise the legal status of their daughter. In short, the judges eventually granted a legalization of their marriage, and the judges seemed to ignore the fact at the time that the husband was still underage and not legally eligible to enter into marriage. The verdict begins by emphasizing that only marriages conducted before the issuance of the 1974 marriage law are eligible for retrospective legalization, but then proceeds to clarify that Article 7.3.e in the Compilasi Hukum Islam opens the possibility for legalizing of all marriages submitted for their consideration. In a nutshell, the verdict declares that such a marriage is eligible for state legal protection. The verdict also confirms that the law on the age of marriage is intended to protect the rights of children as stated in Article 3 of Law 322 on child protection. The judges were well aware that legalizing a marriage in which the bride is underage violates the law. However, they thought that prioritizing the rights of the son was even more important. Now I come to the last part of my lecture, conclusion. In this article, I have shown some of the different paths villagers can take in order to legalize their unregistered marriages and their children. It seems that they are not concerned about whether or not their marriages are legally valid according to national laws, as long as their marriage is socially accepted. They feel content, they feel comfortable. Scholars have emphasized how much more heavily the significance of social acceptance than consideration of state legality. In fact, in the Indonesian legal system, there are several paths that are open to them to legalize an unregistered marriage. First is by having a new marriage ceremony at the KUA in the presence of a penghulu, marital functionary in the KUA. This marriage is undertaken solely for the sake of obtaining the marriage certificate. And of course, it is meaningless as far as the legal status of the children is concerned. And the second way is by seeking legalization by submitting a petition for isbat nikah to the Islamic court. Legal anthropologists emphasize the multiplicity of legal bases and institutions which co-determine the structure, norms, and interpretations of the law. Isbat nikah in Islamic courts provide a space in which judges can exploit the plurality of legal orders. The judges examined the dialectic, mutually constitutive relation between state law and other normative orders. The above cases in my presentation before show that it is often the lowest level of the state administration which is crucial to providing a legal identity to those who would otherwise not qualify. And in the end, it is clear that the judges and also the marital officers in the KUA office prioritize the public good rather than applying the letter of the law. So thank you.